My name is Stephanie Bowman, and I'm a senior program attorney with the National Council of Juvenile and Family Court Judges. And I want to welcome you today to Judicial Strategies to Prevent Firearms Violence through Extreme Risk Protection Orders and Domestic Violence Protection Orders. Later today, we will hear from our expert judges, the Honorable Elizabeth J. Burns from the Superior Court Judge of King County Superior Court in Washington State. And we will also hear from Honorable Jason D. Dodson, Family Court Administrative Judge for St. Louis County Circuit Court. But first, I want to pass it along to our other experts we have here today to introduce themselves, starting with Jennifer Becker.
Good afternoon. I'm Jennifer Becker, and I'm with the Battered Women's Justice Project. And in particular, we operate two OVW-funded training and technical assistance resource centers, the National Resource Center on Domestic Violence and Firearms, and the National Center on Protection Orders and Full Faith and Credit, and I'm representing both of those projects today. Spencer?
Thanks so much. Good afternoon, everyone. My name is Spencer Cantrell, and I'm an assistant scientist at the Johns Hopkins Bloomberg School of Public Health. And in that role, I co-lead the National Extreme Risk Protection Order Resource Center, a project funded by the Department of Justice. Excited to chat with you all today about ERPO laws.
And so we are each grant funded, and so these are our thoughts, opinions, and not necessarily the views of the federal agencies who fund us to do this work. So as the announcement for this webinar had noted, this is really a follow-up with a focus on judicial strategies to a webinar that BWJP and Johns Hopkins ERPO Resource Center put on in October that focused on a review of the similarities and differences between extreme risk protection orders and domestic violence protection orders, two forms of civil court orders. So we want to really leave the bulk of the time in this webinar to the judges, so you can hear directly from them how they're implementing tools like this in their courtrooms and in their jurisdictions. But we just wanted to start with a little bit of a recap, sort of getting back into where we come to be addressing these two tools together. So I wanted to highlight a couple of resources that provide complementary information to what we'll share today. The first is we have a compilation of research that findings that highlight the intersection of domestic violence, intimate partner violence, and gun violence. And so you can access that for an understanding of where the sort of state of research in this at this intersection exists. And another helpful and complementary resource, not done through our OVW-funded projects, but a collaboration between BWJP and the National Domestic Violence Hotline we released in December, is a report with findings from a national survey of intimate partner violence survivors that was conducted in early 2024, specifically around survivors' experiences with firearms threats and harm. And it's really helpful complementary information to the discussion we'll have today, because it really highlights the multitude of forms of abuse and violence and intimidation that intimate partner violence survivors are facing very often, that oftentimes go sort of overlooked, that range from all sorts of different types of threats, but aren't what a lot of the research focuses on, which is fatality. Spencer?
Thanks. And this is a resource we wanted to lift up. It's our website for the National ERPO Resource Center, ERPO.org, which has a lot of information about ERPO laws and how they work in each state. You can click on the state-by-state information and see if your state has an ERPO law. We also have links in there to research and resources to support folks working on ERPO implementation. And I'm also putting in the chat a link, which is also featured on ERPO.org, which talks about the research behind ERPOs around the country and showing that evidence base for the efficacy of ERPOs, which I will also touch on in a moment.
We also want to mention the NCJFCJ's Civil Protection Order Guide Project, which is funded by the Office on Violence Against Women. This project provides technical assistance, training, information, and resources on civil protection orders from issuance to service to enforcement of protection orders, focusing on community collaboration to improve systems and their ability to provide better protections to survivors of domestic violence, stalking, and such, as well as to provide more accountability for those that have caused harm. We also will be releasing in the next week an update to the Civil Protection Order Guide projects, the Civil Protection Order Guide's issues in focus section, which may be of interest to those on the call because it does the issues that it looks at in focus are firearms and firearm surrender in civil protection orders, military protective orders and their intersection with civil protection orders, as well as technology from both systems use and the misuse of technology by respondents. So we'll have that resource coming and it'll be available on our website, which you can locate here. I can also put a link to it in the chat later. But you can also reach out to me, Stephanie Bowman, if you have any questions about resources, training, or any sort of technical assistance questions regarding firearms and civil protection orders, as well as reaching out to any of the other experts on this panel. So thank you.
So we're now going to just go quickly over some of the key differences between ERPOs and domestic violence protection orders before turning it over to the esteemed panel of judges. And like Jennifer said, I know you all might have had access to the webinar that we did back in October comparing these orders, but we just wanted to give a brief high-level overview for those of you who might have watched it a few weeks ago and have a refresher top of mind. So ERPOs are a much more modern, more recently developed tool than domestic violence protection orders. The first modern day ERPO was passed in 2014 in California called a gun violence restraining order. And now 21 states and the District of Columbia have ERPO laws on the books. So not the same level of uptake that we have with domestic violence protection orders. But basically, ERPOs are civil orders that solely address access to firearms. That includes current possession of firearms and ordering the removal of those firearms, and then also prohibition on obtaining other ERPOs for the duration of the order. And so Jennifer will get into it much in a little more detail than me, but ERPOs are solely looking at the firearms, whereas domestic violence protection orders have a lot more robust relief included in them. The folks that can petition or fill out the paperwork asking for an ERPO is much broader in an ERPO than in a DVPO, and would include typically law enforcement in every state with an ERPO law. And then in many jurisdictions, prosecutors and family and household members can petition. And then in 7 jurisdictions, healthcare or mental health providers can also petition for ERPOs as defined by the statute. Overwhelmingly, we're seeing law enforcement petition for ERPOs. And we're seeing ERPOs being used in response to threats to self as well as threats to others. And the research that we have available indicates that for every 17 to 23 ERPOs issued, 1 suicide is prevented. But we also see ERPOs being used in response to threats of domestic violence, workplace violence, mass shootings, and other threats of firearm violence. The standard of proof required is going to vary by state and an ERPO, but the purpose of the ERPO is really to protect the respondent from harming themselves and others, and then also the general public, right? Wanting to make sure that folks are safe from firearm violence. So that is a very high level view of ERPOs, but I'm going to pass it now to Jennifer to talk about some of the key differences.
Yeah, thanks. So with respect to intimate partner violence, ways that these two tools differ, Spencer already sort of highlighted some of those differences. First, domestic violence protection orders are available in every jurisdiction in the country. Every state has some law with respect to domestic violence protection orders in some form, no matter, they're called different things. Whereas ERPOs, as Spencer said, are not available yet in every jurisdiction. With a domestic violence protection order, it's the intimate partner who petitions, and if it's issued, it becomes the protected party. And the really key difference here is that domestic violence protection orders offer a wide range of potential remedies, so they really can be tailored to the specific victim survivor's situation and risk of harm. So domestic violence protection orders can remove firearms, remove access to firearms during the pendency of the order, like ERPOs, but can also address other risk of harm. So stay away, prohibiting other forms of contact, providing for at least interim or temporary housing, access to a shared home, providing at least on a temporary basis, things related to children, could protect named children, could provide for custody, visitation provisions, so a wide range. And do you want to speak to some of these differences or ERPOs in these contexts?
Sure. So like Jennifer said, it's really just about the firearms in the ERPO. But again, that's firearms removed that are currently possessed, as well as it's listed here, entry into the NICS and NCIC databases. And once someone is entered into the National Instant Background Check System, they would be prohibited under federal law from purchasing firearms for the duration of the order. These orders are typically in place for 6 months to a year. In some states, it is longer. Best practices, we encourage recommending that folks review orders before they expire and make sure that the threat that gave rise to the need for the ERPO has subsided before that order is over and the respondent's firearms are returned. Regarding enforcement, prosecutors or law enforcement are the ones that can enforce these orders and file contempt or other court remedies against the respondent. But we often see family members, loved ones, other individuals contacting them regarding the enforcement of the ERPO. Back to you, Jennifer.
Yeah, thanks. And on that enforcement piece, it's another key difference for survivors of intimate partner violence to understand between the two tools and remedies. As the protected party, survivors can seek enforcement depending on the jurisdiction, civil and or criminal enforcement of the order where potentially violated. And DVPOs have really clear statutory and body of law around full faith and credit in other jurisdictions should they move to another state. So those are some sort of key things for survivors to be aware of, distinctions depending on the jurisdiction. And the duration here can be different as well. Again, it's dependent on individual state law. But final orders can range from 90 days to indefinite. There are some jurisdictions that have indefinite orders given the circumstances in the case. So a few recommendations to keep in mind, and that was a very, very brief sort of high level overview. So if you have not seen that earlier webinar, you can access it on both BWJP's and Johns Hopkins websites. Each of our projects also have written resources on this topic that you can access, or you can reach out to us and we're happy to send them along. But a couple of recommendations to keep in mind. One is it's really important as a judicial strategy to understand the nature of how firearms threats and harm show up in intimate partner violence situations, the range of ways survivors are being harmed, threatened, coerced through firearms, and how that relates to their increased risk of injury and fatality. And also to be attentive to how that might show up in petitions or in testimony that come before a court. Because oftentimes it's not maybe the lead allegation that a petitioner or survivor puts forward, and it might come out in maybe what some of us would consider a more subtle way. And so understanding the research and what we know about domestic violence facilitated with firearms, looking for that behavior in petitions and in testimony, and really understanding what danger that's representing. I know that survivors are not a monolith, so the decision to seek a domestic violence protection order or an ERPO or both, given the jurisdiction, will have been made after consideration of a multitude of individual factors for that survivor and their family. And so, sort of take nothing from which path or a survivor chose or didn't choose. So we definitely hear from survivors who choose to navigate the path for an ERPO for their own sort of calculations around their safety, and vice versa. So survivors who want remedies around prohibiting their abuser to continue to access firearms, and want to do that through a domestic violence protection order that has a robust protection around firearms risk, among others, and know that it will be implemented and enforced. So we are available for any other technical assistance that you all might need. Both the National Resource Center on Domestic Violence and Firearms and the National Center on Protection Orders and Full Faith and Credit at BWJP, and the National ERPO Resource Center at Johns Hopkins University. So please reach out. And now we can turn it over to Darren, so we can have a great conversation with our two judges today.
Thank you so much, Jennifer and Spencer. Appreciate that very, as you said, brief overview, and certainly go back and look at the previous webinar. Plus, ERPO.org is really an amazing resource on issues around ERPO, and both Jennifer's organizations and the National Council are available to help you on domestic violence protection order in issuance and enforcement, especially in the context of firearms. My name is Darren Mitchell. I'm a fellow with the National Council of Juvenile and Family Court Judges, and I've been working with Stephanie and Cindy, who's joined us, and others at the council on our civil protection order implementation project that Stephanie mentioned previously. And I'm just going to say a couple things and then really get out of the way so we can hear from our two judge panelists who are here to share their strategies and approaches on these issues. So we wanted to talk about some sort of overlapping or overarching specialized practice and strategies around addressing people who are prohibited from having access to firearms, their possession and access to those guns through DVPOs and through ERPOs. What are some of the overarching issues that we see communities and systems struggle with? And two, that often rise to the very top when we're talking to judicial officers, but others as well, around implementing these laws effectively, are first, the court that's going to issue the order, and then ultimately law enforcement who may be responsible for serving the order and maybe getting firearms at the time of service and or enforcing any violations of the order, need information to issue orders that are going to be specific as to the firearms that may be involved, the person may have access to, how people can go about complying with those orders to surrender, the specifics of how you do that, instructions and things like that, and ultimately for those orders to be enforceable by folks. So information is really key, and many folks will tell you it's hard to know what people who are causing harm to others have in the way of access to firearms. So we're going to talk about that aspect to some degree. We're also going to talk about another key element, which is really moving away from what is in essence, in many places, an honor system where if an order is issued, whether it's a DVPO or an ERPO, and you're ordered to relinquish your firearms, what's the follow-up to make sure that you're doing that? Is it just an honor system? Are people who want to comply the only ones who do comply? Or is there more accountability built into the system? So we're going to talk to our judges a little bit about that, and specifically about monitoring compliance with DVPOs and ERPOs that include the requirement that you relinquish your orders, and how review hearings can be effective components of those. So let me go ahead and we'll have our two judges introduce themselves. They come from two different parts of the country. They both help develop and implement really innovative approaches to firearms and intimate partner violence cases. And happily for us, they're both willing and very effective at sharing their strategies and their perspectives with judges and with others on these issues. So we have Judge Elizabeth Burns from King County, and I'll turn it over to you first to introduce yourself, please.
Okay, thank you so much, Darren. And welcome everyone. Happy New Year. I'm Judge Elizabeth Burns. I reside in King County, Washington State, which is in Seattle. There, I sit in a general jurisdiction court. We serve 2 million people in our county, and have been working with extreme risk protection orders now for almost a decade. Since 2016, when I was part of the original work groups that spoke with different community members and stakeholders on how we could address issues of firearm violence in our communities pre-2016. So I'm thrilled to be here, very honored to be talking alongside Judge Dodson. Thank you very much.
Thank you, Judge Burns. Judge Dodson, would you introduce yourself, please?
Well, thank you. It is my honor. There's so much great work that has been done in King County. I will tell you, been admired some of the amazing and innovative approaches there for a long time. But I am from St. Louis County, Missouri, and I am the administrative judge of our family court, which includes a domestic violence civil protection order court. We've had it for about 14 years now, almost 15. And we do not have ERPOs. We only have the domestic violence protection orders. So I can be addressing that. Before I've been a judge since 2016, and I've seen just about every level of domestic violence sort of interfacing with our system. I've done just about everything you can do as a judge, from issuing orders of protection. We have a monitoring and a contempt process. I've done the felony domestic violence work as well. Very interested in this topic, really honored to be here also. And I will tell you, the laws in Missouri surrounding firearms are virtually non-existent. So we'll see how that plays out.
Yeah, we certainly have. Thank you, Judge Dodson. We certainly have kind of the opposite ends of the spectrum in a lot of ways, because the laws in Washington State have been refined and refined over and over again to a point where they really serve as a model for folks all over the country. And so let's start off with you, Judge Burns, in working in King County. And we're going to start off talking about this issue around judicial officers and the system obtaining information about folks' access to firearms when they're prohibited from that access. Would you please describe for us the steps that you and your colleagues in King County use to make sure that you do obtain the information that you need to determine whether, in the instance of an ERPO, whether to issue an ERPO?
Certainly, and thank you for the opportunity to do that. Just to provide a little bit of context, our extreme risk protection order numbers on average over the last, if we look at last year, which we're still pulling in numbers, and then 2023, we have an exclusive track for extreme risk protection orders, in addition to domestic violence protection orders, sexual assault protection orders, anti-harassment, vulnerable adult protection orders, and the like. So on the exclusive track of extreme risk protection orders, we had approximately 124 filings in a year in our county. So it's not a huge number, but again, it's a dedicated track. And of those 124 filings, we have issued a majority of those, and many of those, if not all of them, 120, come in through law enforcement. And so that will get me right into answering the question about where our judicial officers are getting the information. to evaluate the petitions coming in and make the decision on whether to issue the order. I'll also tell you, just to close the loop on the numbers, that of the 124 filings that come in, we've collected on average with those numbers about 355 firearms. So it's a big return on what's coming in the courthouse door. So all of the information that we have to evaluate the initial request comes via paper to us. And then we have a hearing on an initial request for an extreme risk protection order. So there's a petition that comes in, and as I indicated, a majority of those petitions are completed by law enforcement. So as you can imagine, law enforcement and community members, including family members who are concerned about individuals preventing the access to firearms or ensuring the removal of those firearms, are really actively working before it even gets to the court to prepare the information so the court can really streamline and look for what it needs. So there's a petition that's completed. It's a very user-friendly form that's gone through various iterations, including a recent statutory change in the last couple of years. So that's very comprehensive. It's very straightforward. It's actually supposed to be fairly simple at this stage, but it does contain a lot of information. We'll also receive information about an individual's criminal history. We'll have an idea of whether there's an active case. It's not always the case that there's a criminal case that's pending as a result of a concern on firearms. Most commonly, that'll happen afterwards if it's related to the ERPO petition. And then we'll have statements provided by the officers that have responded to an incident. We might have family statements. Once we have all that information, there is an initial hearing. That happens by Zoom. We do virtual hearings on that and prioritize those cases. We prioritize them on our calendars too, so that we have access to the prosecuting attorneys that come forward. We have a law enforcement officer available, and the court can review the information and ask questions after that's been presented. And then that really gives us everything that we need to have to make the initial decision for the issuance of an ex parte extreme risk protection order, which then sets a subsequent hearing 14 days afterwards to get full information, more information, and include the responding party so that we can consider all that before issuing a final order if the court decides that we do that. And I know that Spencer had put up some information on the standards that we apply. We have a preponderance of the evidence standard here in our county and in Washington state, whether or not there's a significant danger of personal injury to self or harm to self or to others. And so we review all that in that context.
Thank you, Judge Burns. I'd like to ask you a very quick follow-up before we get to Judge Dodson. And that is, if it's an ERPO in a case that involves intimate partner violence, you'd mentioned that you may sometimes at the ex parte phase and maybe also at the final hearing get some information from the family. Would you, what if any information do you get about the victim's desires in the case if it is an intimate partner violence situation?
Yeah, and most of that information is coming through law enforcement because the law enforcement officer has obviously spoken with individuals in that situation. So we don't require that we have a victim coming in and that's going to complete a declaration or statement unless it's a family that's initiating the petition for the extreme risk protection order, in which case we do need that information in the form of declaration. So it's mostly coming through law enforcement. Did that answer your question?
Yeah, and I'm assuming that, and I know the system there somewhat from having worked with them, that conversations with the victim and whether to proceed, how to proceed, take place, of course, not in the court at the hearing, but you're really relying on law enforcement, maybe working with the victim, maybe working with victim advocates to have those conversations.
Absolutely. And thank you for mentioning the advocates, because we do have a very robust advocacy program for extreme risk protection order matters that come through. And, you know, honestly, the feedback that we've received through our evaluation of how well this is working from community members and from family members is really just overwhelming gratitude that comes from victims and families, that law enforcement and the courts are coming in and actually providing that assistance at that stage. And it isn't uncommon that we would actually hear from an individual whose access to firearms and weapons has been restrained later on, saying, you know, thank you for basically doing a massive legal intervention that prevented a lot of harm in families. And so there's a lot of work ahead of time. And by the time that our judicial officers get the packet in there, that work is well organized and it's ready to be evaluated on a very rapid emergent basis.
Thank you. Judge Dotson, I know your work is around domestic violence protection orders in St. Louis County. Would you please describe to us some of the strategies that your court uses around getting the information that you and your colleagues need to issue orders to relinquish firearms that are going to be effective?
Sure. Thank you. And I just kind of marvel at the ability to do what you do in King County. As I mentioned, we don't have firearms laws in Missouri, and I say that, but we still believe we have the authority in our civil protection order statutes to order firearms to be relinquished. We have a sort of a catch-all that if we issue a full order of protection, we can issue other orders to protect the safety of the petitioner. So with that language, we've set up a system to do so. Now, I think the best way that we get information at both the initial stage of the filing and what's in the petition to the evidence at the hearing is with the help of advocates. Our court welcomes advocates. We actually fund an advocate who assists folks filing for protection orders. We have just under 1 million people in St. Louis County. We have about 4,000 intimate partner civil protection orders filed a year in our county. We are the largest in Missouri. So it's a booming department and area, unfortunately. So advocates try to tease out this information, I think, in the petition. What I have found, and I did 10 years of legal aid work for survivors, that sometimes is counterintuitive as it may seem, that the firearm may not be top of mind for a lot of the petitioners. So I think that can really help to have somebody who's trying to, get this information and put it in the petition, because that can be very helpful for the judges who review to issue an ex parte. And then, of course, when we get to the hearing, hopefully by that time, the advocates have been able to, help the petitioner develop testimony or organize testimony. And again, if firearms are a concern, make it something that the petitioner is bringing up in their evidence. I will say that it's appropriate for us from the bench to ask about firearms. And so we have a system where we attach certain special conditions to our full orders of protection. So we have a state form that we're required to use when we issue what we call the sort of full order. But then we added this other form. And so we work with our judges who are handling these to be sure to inquire about firearms, because we want either a finding that there's no credible evidence that that the respondent possesses one, or that there is credible evidence, and then we order relinquishment. So again, that's really the best way to do it. We do not have law enforcement weighing in typically unless such person may be called as a witness. We may have other family members who can weigh in. So it's an imperfect method, but it's kind of, I think, it works pretty well.
Thanks for sharing that, Judge Dotson. And certainly for those of you who are working in jurisdictions that don't have the comprehensive legislation that King County and some other places have, I think this is an excellent example of what can be done with that so-called catch-all. We've worked with other jurisdictions that have developed firearms relinquishment programs based on the judicial officer's inherent authority to include relief that's going to protect the parties involved. And so certainly reach out to us if you have questions about your own state laws and whether you can initiate a program like this. I was just going to turn it over briefly, Judge Burns, if you had anything to add. I know that you and your colleagues issue domestic violence protection orders as well. Anything to add on that side of things as compared to the ERPOs that you described earlier about getting the information to the court?
Sure. And I think with the domestic violence protection orders, we have a statute that requires the order to surrender weapons, provided that, as Judge Dodson was noting, that the evidence comes in to indicate that there's a concern for that, or there's an active threat for that, or there's a threat, or there's a showing that that's involved. And even just the nature of the relationship can automatically trigger an order to surrender weapons as a precautionary measure. So all of that's coming in. We also have sheets and forms that have pictures of different kinds of firearms, and people don't really know what it is, but they can circle. You know, in those cases, we don't, for DVPOs, we don't have law enforcement coming in with those. Those are individuals that are coming in. So we try to make that as user-friendly as possible. So seeing the pictures, getting an idea, obviously reading people's statements and asking questions, again, is what the Judge Dodson had indicated. We absolutely will be very interactive with individuals coming in on these calendars for this kind of protection, and asking the right questions and making sure that we're getting the information that we need, and fully understanding the nature of what's going on in the context so we can evaluate it appropriately.
Yeah, and what a great message that sends to respondents in protection order cases, that the court is interested in this, is concerned about this, and is taking it seriously. And for those of you who haven't seen the interview guides and sheets that Judge Burns mentioned, reach out to us. We can get you copies of those. There are now, and you may already know this, Judge Burns, there are other communities around the country. I think St. Louis County has adopted it as well. That approach to helping people describe to the court and to others what types of firearms the person who's causing them harm may have access to. Great.
If
Judge
I
Johnson.
may, something else on this topic that occurred to me earlier. A lot of the time we have parties who want to enter into consent protection orders on the petitioner side, if respondent's willing. Understandable, you don't have to give testimony in our circuit to do that, or in our jurisdiction and so on. So one of the things I wanted to emphasize is we do have sort of protocols for opening remarks from the bench when these dockets start. And included in that is, if you are concerned, petitioners, about firearms, be sure that when it's being, when you're talking about what you need to accomplish in your full order, that you raise that issue. Of course, we don't let people negotiate directly and that kind of thing, but there are enough of them that it's important, I think, to put that out there right at the beginning. Sorry.
Yeah, thank you very much. And for those of you who are aware of the federal laws that apply in these cases, specifically the Federal Gun Control Act, 18 USC 922 G8, it applies consent orders of that format, as long as the person had an opportunity to be heard, trigger that federal prohibition as well. So it's important to be cognizant of that. Judge Burns, were you going to mention something else?
I just wanted to mention that in addition to the information coming in about the circumstances, and this goes back to the extreme risk protection order track, is that we're also looking for information that's going to help us make a decision on whether to require some kind of a mental health evaluation. So that's more than just possession or threat to possess or access. It's about really what's happening in this individual's life, as is reported by family members mostly, so that we can follow up as is very customary in the ERPOs, and order that evaluation and get community services involved, so that there can be ultimately some healing and some safety and some closure.
Yeah, thank you so much for mentioning that, Judge Burns. And I know that's I know there's a push to help to figure out how to help people who are suffering from behavioral health challenges, and the ERPO, this process can offer kind of an entree to doing that. So thank you. I'm going to shift us to a conversation now around this honor system compliance monitoring, making sure that people, if they're ordered to relinquish their firearms, that they do so. So let me start with you, Judge Dodson, if that's okay. Can you talk to us a little bit about what you and your colleagues do once you've issued a domestic violence protection order that includes firearms relinquishment, what's done to monitor whether the respondent, in fact, relinquishes those firearms?
Sure. So we do have, we're fortunate to have a pretty robust domestic violence court staff, and could go on about our creative sort of grant writing for that. But so what these full orders of protection will have in it an order to appear at a compliance hearing that the respondent will obviously receive. Now, those hearings are held, these are just to monitor compliance and, if appropriate, handle a civil contempt motion. So respondents who are present are meeting with somebody on site we have a respondent case manager who intervenes at that point and says, here's what this order requires of you, and here's this return date. Here's how you can comply with the firearms relinquishment order. And we do have a few options for that. They then would appear at the monitoring docket. And again, this judge is not there to rehear the order of protection and hear about how wrong the other judge was, but rather just to make sure the person is in compliance. And if they're not, how they're going to get into compliance sort of immediately. I mentioned civil contempt. Sometimes people just are getting the picture, and I would say often if these orders are issued without the person present, sometimes it's their first appearance. So we have these dockets twice a month. So this person might appear on the first docket and then come back 2 weeks later to see the other judge, because now they understand, at least it's been explained, and they have no excuse for noncompliance. So we have really great compliance staff that are very invested. They have relationships with law enforcement. They have relationships with licensed gun dealers. We also have a process where somebody could relinquish to a third party, and we have a system that requires that person to appear before the court also and give sworn testimony and so on. Sometimes people are concerned about their rights and making statements without counsel, and so we have access to an attorney available in those situations. So that's what we do. And people that simply refuse, if they could comply and are refusing, we could then proceed on civil contempt. Our compliance office initiates a simple motion, and then if found in contempt, there's an opportunity to purge or have the consequence until they agree to do so. That could include sitting in our county jail. And we have some folks who can persistently refuse, and they could be then held in what we call indirect criminal contempt. We have a process for that. Now, that's mostly for contact violations, which we're not really here about today, but for those folks who maybe said they relinquished or said they don't have firearms and then are later found to have them, may be facing indirect criminal contempt, and we can talk about that in a moment. So that's really the process. And I think the part of our compliance piece that really makes it work is our compliance folk. I mean, they are not there. It's not a game of gotcha, right? Their role is to make sure people are successful and talk through these strategies. And sometimes after the person is sort of over the initial of shock of, you mean I can't possess a firearm for hunting, even that kind of thing, that they work pretty savvily, I guess is maybe the way to put it, to get people to comply. So it can be very effective.
Thank you, Judge Dodson. And I have to say that theme of setting people up for success and then creativity in how you talk to folks who, many of whom just, want to comply, they don't want to get in trouble, is really kind of an art that many jurisdictions, King County has developed. They have, as Judge Burns knows, some amazing people doing that work. And other places around the country, we've seen that. If folks have questions about how to make a system like this work, please do reach out to us. We can connect you with the individuals. Judge Dodson has a compliance officer who does really spectacular work. That initially was funded through a STOP grant, an OVW grant that is available in all of your states, and is an opportunity to maybe seed or pilot a program like this. So definitely reach out. We want to be able to help you get something like that going in your community, no matter kind of where you are. But let me turn it over to Judge Burns now for your response to the question around monitoring compliance and making sure that people comply with orders.
Similar to what Judge Dodson just explained, we have a compliance review calendar And for our protection orders, including our domestic violence protection orders, where there was a companion order to surrender weapons order, those are all set on a dedicated calendar. And the individual respondent is given notice of the onset. It's right on the first page of the order that's been issued, whether it's the initial ex parte order or whether it's the full order on the compliance date, and how to appear for that hearing and what to file, and how to be prepared for that. And then that goes on for compliance. For the extreme risk protection orders, those are served, as is required by our statute, by law enforcement. And at the time of service on the individual, the weapons are collected. That is the absolute goal of those extreme risk protection orders. A little bit different from the domestic violence protection orders and the order to surrender weapons. It's not always quite streamlined with the collection by law enforcement. It's not always the case that law enforcement is going to be serving those other protection orders, but it is so with the extreme risk protection order. So we're hoping to collect as much or ensure the collection so we can ensure the safety that we've just put into place in the order at the time of service of the order. But we still set that for compliance review, again, provide a clear date and a dedicated calendar so that we can have the prosecuting attorney who's assigned to that and our law enforcement officers available. And then just again, as Judge Dodson indicated, really wanting to ensure the success that we accomplish what we're trying to accomplish here. It's not about taking rights away, it's about ensuring safety. And most people are actually leaning into that, even individuals that have to turn over those weapons. Once they understand what the concerns are, they lean into it. And it's a fairly successful way of going about that. I think in any system, having that judicial follow-up, having the judicial review on that really ensures success, holds people accountable, and also communicates the support overall.
Terrific, thank you. And Judge Dodson, just to close the loop on we're setting people up for success. They repeatedly don't succeed. They know what they need to do. They don't. Can you just say a quick word about your contempt docket that's been established?
Sure. So we also have 2 contempt dockets a month. And as I mentioned, these are usually for contact violations where the prosecuting attorney just doesn't have time to get involved. But we have people who persistently refuse to comply with our relinquishment orders and some of our other orders. And the compliance office can initiate a process to have those folks come to that docket. Yet another judge will be in charge of, again, not trying to rehear any evidence or hear explanations, but rather to determine if the person could comply, if they're refusing to comply, and then there can be a criminal sanction, if you will, through indirect criminal contempt of court. It just means there's a violation of the court order that's happening outside of the view of the judge. We have volunteer attorneys who we appoint as kind of like prosecutors. We have defense counsel available as well. Most of these folks are grant funded if they're not volunteering. And, it's full due process. We have hearings. We use a very high standard. We use beyond a reasonable doubt for criminal contempt. And, serious violations can be punished with jail time up to 6 months or fines. And typically when somebody lands on that docket, they're going to realize how serious we are if they haven't received that message already. So that is the enforcement piece. And yes, less about success and more about consequence.
Thank you, Judge Dodson. I'm going to shift us to another topic that I know from working around the country is one that's it's kind of a perennial challenge, and especially in the context of firearms, and that's service of process, service of protection orders. I know that my colleagues with me from BWJP and from Johns Hopkins, we've been working with lots of communities around how to improve their service of civil protection orders, how to prioritize them. how to dedicate units so that that service will be really an effective part of the process, to learning about people's access to firearms and even getting relinquishment of firearms in particular cases. And I'd like to ask you both, from your perspectives as judges and thus as leaders, you know, in your system, can you talk a little bit about how judicial officers can work with your partners to promote safe and effective service of process for domestic violence protection orders, ERPOs, around firearms? Any ideas you're willing to share? And I'll start with you, Judge Burns, please.
Certainly. So on the extreme risk protection orders that I indicated a little bit earlier, that the law enforcement is doing the service primarily on those. They've already had the contact with the families, and in many cases, they've had the contact with the individuals, either from prior incidents or just familiarity with responding to calls of concern. So they're in that position. They get out, they serve it, they interact, they get the firearms retrieved, and that kind of closes the loop on that. Occasionally, in an ERPO type of proceeding with service issues, there might be a situation where the dangerousness to law enforcement and or the difficulty in trying to get somebody served requires that there's a request for alternative service. In which case the court will evaluate that and make findings that there have been due diligence in getting service to the individual, and then provide for another means of service. And most commonly, that's electronic service versus a service by mail or service by publication, which back in the day were the only other alternatives. In our protection order matters, our domestic violence protection orders with order to surrender weapons, again, with the order to surrender weapons, you're getting law enforcement involved a little bit more. But where you don't have that, you're going to have individuals working hard on service issues. Even with law enforcement, it gets to be very difficult to serve on those. And so our statute and the way that it's been retooled recently really requires that there be several attempts at that. And then after a couple of attempts, if that's not working, we look at service by electronic means. Do we have an email address? Do we have a social media account? Do we have cell phone for text messaging? Anything that's going to provide that notice along it as it can be verifiable by law enforcement for the most part that they sent that out is going to satisfy the court in terms of service requirements. So that alternative means is very commonly used. And also, you know, we set up our system so that just because there are difficulties in service after several efforts doesn't give the judicial officer a basis to dismiss the case and tell the person to start over at some later point. So we try to keep them on track, and that's why we really emphasize that alternative means of service.
Thank you. And I can also share from having worked with folks in King County that that the law enforcement agencies responsible for service of orders have really kind of initiated this approach of developing service packets where they investigate the criminal history. You have a database of purchases that are available in Washington State, which most people don't have. They can look at that. They can look at previous interactions with the law enforcement agency to kind of develop a dossier or a packet of information so that the officers going into the service can know what they're walking into and do it safely, but also take an approach that's going to be kind of conversational and trying to get the information, set people up again for successful compliance. And that's they found to be very successful as well in King County. I'll turn it over to you, Judge Dotson, for anything that you can share learning around service of process from St. Louis County.
Sure. Well, we're a bit hamstrung by the law on this. We have no, I think, direct authority that would allow us to order surrender or, you know, even taking the firearms at the time of service, unfortunately. Now, so again, we have to be creative, and we have an additional challenge that our sheriff, who does most of the civil process serving, does not have any law enforcement authority. So we have about 80 different police departments in our 80 plus municipalities within our one county. So with those challenges, what we try to do from the bench is educate on the entire order of protection process, which includes, of course, service and then how to identify these orders that we have. these additional orders for firearms relinquishment. And it's very uncommon that would, I guess, bear fruit really in a firearm being seized. But we try to get it out there so that, as many opportunities that are there in case there's some concern that law enforcement may be bringing to the service. I will also say that we found it best to try to get to law enforcement at the academy. So we're getting a lot of new recruits. We start talking to them at that point, and then we connect with our many police chiefs as at many different times when they meet as a collective group of chiefs, or when they're doing maybe their morning calls sometimes. So we just try to really be interfacing with law enforcement a lot, showing that we want to partner with them. And they will tell you that these are obviously can be very dangerous times for their work too. So, I think it helps to do that, but I wish we had a bit more statutory support.
Yeah, I appreciate you both giving your perspectives from your different sides of this spectrum. But we only have a couple more minutes left. So before I'm going to ask you to for some closing remarks. But before I do that, I want folks who are on this webinar to recognize we've thrown a lot of resources at you. You've heard a lot from the judges, lots of examples, lots of ideas. Hopefully things are percolating. Please do reach out. You have the National Council of Juvenile and Family Court Judges. You have at least a couple of arms of the Battered Women's Justice Project, and you have the Johns Hopkins University Center for Gun Solutions available to help you on these issues. So reach out. We're here. It's free help. We train. We provide one-on-one assistance, ongoing assistance as you develop processes and programs. Please do reach out with any questions or ideas that you want to pursue. So I'll ask you both for just, a quick wrap up. What kind of guidance would you have overall for folks on this webinar today in terms of steps that they can take right now to do something in their community to make sure that ERPOs or domestic violence protection orders are effective tools for survivors of domestic violence where there's firearms involved? I'll start with you, Judge Burns.
Well, I would just encourage community connection. This is just one area where we're dealing with so much trauma in our community, and we're dealing with an excess amount of mental health challenges, in addition to family violence. And it's just, the very worst possible combination of things that anyone can imagine. And so having the connection to community and really the court working as a partner with community members and resources, I think is a key, because you're constantly having to evaluate the effectiveness of the system. Is it meeting the needs of those individuals? Is it ensuring safety? In the case of firearms, are we actually collecting firearms? Is it working? Having training and community outreach, not only training of the bench, but also community outreach, educating the community and individuals about what resources they have with the courts, and then how to get there and the steps to do that. I'm really partnering with all those professionals so that you can take a team approach, because any one player of that just is not going to ensure the success moving forward. And it's a constantly evolving system, and it's a constantly evolving need that has to be carefully tended to.
Thank you, Judge Burns. Judge Hudson.
Yeah, I certainly agree with that. Absolutely. And, some of our, I would say our better practices were just born out of what other jurisdictions have done, and interfacing with our community partners, and having people look around the country, look for these resources. And I love that all these resources are going in the chat. I mean, that's exactly what I think is a great thing to do, to look at these models and then think about how that can be implemented, even on a very small incremental basis. Try to find somebody on the bench who's willing to take it on and make those changes internally and administratively to make it happen too. So that would be my suggestion.
Absolutely. Well, thank you so much, Judges Dodson and Burns, for inspiring all of us, for being here and giving of your time. And thanks to everyone who joined me, my colleagues at the National Council of Juvenile and Family Court Judges, Johns Hopkins University Center for Gun Violence Solutions, and the Battered Women's Justice Project. We really appreciate it, and we'd love to hear from you. Take care, everyone, and stay safe. Bye.